and welcome to another webinar in the AlphaStaff webinar series. Today's topic is unemployment claims management. Our presenter today is Pam Nading, who is a senior unemployment claims manager. She's been with us for a long time and has been in the industry even longer. She's specialized in unemployment claims and SUTA tax management for 20 years. And like I mentioned, she's been with us for 10 years, since 2008, managing unemployment claims and hearings. She previously held roles as an HR generalist manager and also 15 years with human capital experience. Pam has successfully and continues to successfully manage employee relations, recruitment not so much, but definitely unemployment compensation cost control. And her history has been working with $1 billion recruiting and flexible staffing companies' national headquarters. If you are working with Pam on any case, you are in great hands. So without further ado, I would like to turn this over to Pam. Thank you, Pam.
Thank you. Thank you, Sandy, and thank you for the nice words. And thank you today, everyone, for joining our webinar. I hope you find it informative. And what I'd like to do at the beginning of the webinar is set expectations and what I'd like to accomplish in terms of training objectives. I'd like to give you a general overview of unemployment and how it's financed, what entitles a person to unemployment as well as disqualifies, what is in it for the employer in terms of compliance, any critical documents that can mean the success or failure of an unemployment claim protest. What are the best practices when an unemployment claim is received? How do we partner together? What are our mutual goals? And then an opportunity for questions. And I ask that you please save the questions until the end, and we will have an opportunity at the end to review those. So without further, what is that general overview? Unemployment was actually enacted in 1935 when Congress enacted the Social Security Act. It's a federally mandated insurance program which is state administered. So what does that mean? The state runs the program, the federal government determines whether or not the program is satisfactory. The purpose of unemployment, which was, as I said, designed in 1935, was to provide temporary relief to individuals who lose their job due to no fault of their own. It's supposed to be a temporary relief. Each state is entitled to create their own governing entity for controlling unemployment conditions. They determine their qualifying conditions, benefit levels, disqualifying provisions, and how they will determine the rate that an employer pays. In addition, in order to have a successful state-run program, it must conform to certain federal mandates, which we will discuss today. So how is unemployment financed? You know, I hear frequently from individuals who apply for unemployment, the scenario is, I've been working for 20 years and I've paid money in there and I feel that I deserve unemployment. Well, in most states, it is not paid by the employee. There are only less than a handful of states that actually allow the employee or require that the employee make a small payment. Thinking of two off the top of my head would be New Jersey and Pennsylvania. In most states, it's totally employer financed, and that's done through a tax paid on the first dollars each employee earns. The rate of tax that an employer pays, which can be anywhere as low as 0.1% up to say as high as 10% on wages as low as the first $7,000 or as high as the first $32,000, depending on the state. And you could see there's a lot of fluctuation there, is based on several things. One, the claims an employer loses. Two, the size and fluctuation of an employer's payroll. And three, the general health, unemployment health of that state. The good news is right now, unemployment, it is at an all-time low. Our current unemployment tax rate is at 3.9%. That is an 18-year low. So how does that translate to most businesses? Well, in most states, the rate an employer pays is similar to a checking account. The cost of a loss claim is subtracted from those dollars that you're paying in on those employees, called employer contributions. The lower the account balance in relation to the size of the employer's payroll, the higher the rate. The reason is because the state wants to make sure that you have sufficient funds on file should someone file for unemployment to cover the cost of that claim. So in other words, if you're growing in a time when unemployment is low and companies are adding to staff and they're seeing increases in their business, the state might ask you to build up your account balance in order to cover what might be lesser periods of employment growth. You may still be paying claims also from as far back as 3 to 5 years ago. In most states, an unemployment claim is used in the calculation of the rate for at least 3 years. Some states 5, and in some states, it never actually leaves. So that rate, that unemployment claim where John Doe collected $6,000 when 3 years ago he was laid off, is still going to be used to calculate your tax rate 3 years later. An employer actually pays in tax at least the amount of the claim, usually much more than the actual cost of the claim, because it's considered in future tax rates for several years. An increase in payroll can also negatively impact an employer's tax rate. As I mentioned, if you're growing and the state is seeing growth in the company and they begin to see that the payroll is higher than the employer's account balance, then that particular employer might see an increase in rate, even though they're doing great, even though they haven't seen new unemployment claims. So your rate can be controlled or affected by many things. Our goal is to monitor all of those, to be as competitive as we possibly can, and to win as many cases as we can, so that that part of the rate that we can control, which is claims that could be lost, are kept to a minimum. What's the other side of that from a payroll standpoint would be, because the employer pays a tax on the first dollars earned by an employee, if you're good at controlling your turnover, then you're going to pay in less in taxable wages, and that will also assist in controlling your tax rate. So what are some of the eligibility conditions? What are the conditions that would entitle a person to unemployment benefits? The first one is that the person has to be unemployed or partially unemployed. They have to be able to work, available for work, actively seeking employment, and have sufficient prior wages to qualify monetarily, which is a very minimal amount. In addition, they have to have separated from their last employer for a work-related reason considered beyond the control or for good cause. And we're going to discuss those reasons in detail. In terms of being unemployed or partially unemployed, let me also say that if you recently lost your job, or maybe you have had reduced hours, you may be entitled to unemployment. If you are still working for the company, they're no longer able to provide you with the same hours, it's not a set schedule, you're working as needed, then the state will take that into consideration if the individual is willing to say that they're seeking suitable other work, and that individual might be drawing partial unemployment benefits at the same time that they're working for you. In terms of being able to work, the state looks at whether or not they're medically able to work. Has this person just recently Sandy, has this individual just recently become unemployed or advised you that they're no longer able to work? That also can influence a particular unemployment claim. I believe I may be having technical difficulties with my speaker. If you're unable to hear me, please let me know. What are some of the disqualifying conditions? In unemployment, an individual will be determined ineligible for benefits if they voluntarily resign without good work-connected cause, or if they're discharged for work-related misconduct. Again, the key here is that it's work-connected. If a person resigns, I have a case this morning, the individual worked for the employer for a very short period of time. He resigned for reasons that he felt were justified. He decided that he didn't like the pay after all, that he didn't like the type of job he was doing after all, and that he felt that he should be making more money. But he was denied benefits because the state determined that all of those things were reviewed with him at the time of hire. The conditions of employment had not changed. Therefore, his reason for separating from the employer was without a good work-connected cause. In terms of being discharged, an individual will be denied benefits if they're dismissed for work-connected misconduct. Now, how is misconduct identified? Misconduct is identified as any willful, wanton, deliberate act that's in disregard of a standard of behavior that an employer has a right to expect. Something that they do repeatedly, or a deliberate act of negligence, not an isolated instance of poor judgment. The state also looks to see if the employer was harmed in some way. As a result of the claimant's misconduct, did the employer lose a customer? Did the employer lose revenue? Was the employer's reputation harmed? Could the employer potentially lose a large client or a client in general? All of those are things that are taken into consideration. Lastly is the burden of proof. When the employer is the moving party, when the employer determines to disqualify or to discharge someone, the employer, considered the moving party, must prove their case. It's the old innocent until proven guilty. The employer has to be able to prove that the claimant knew what was expected, that the claimant willfully violated, that the claimant knew what the consequence could potentially be, that the incident was either repeated so often that the claimant is now culpable and responsible for dismissal, or that the incident was so serious that it warranted immediate dismissal. In most states, if the employer is able to prove that, and we do it every day, the individual is disqualified until they re-enter the labor market, earn at least 4 to 17 times the weekly benefit amount, and then again separate from a new employer for the same non-disqualifying conditions, i.e., were laid off due to lack of work, separated due to no fault of their own. So what is the difference between, because we see this very often, poor performance versus misconduct? Frequently, we will see on one of AlphaStaff's separation documents that the individual was discharged for failing to meet expectations. For us, we need to know, because that is considered a poor performance category, whether or not this is a case of true lack of competency in the case of poor performance or work-connected misconduct. The current slide gives you a definition of both. In the case of poor performance, the individual simply cannot do the job, whereas in comparison, an individual discharged for misconduct will not do the job, is fully capable but chooses not to. In the case of poor performance, we have someone who is genuinely unable to meet the employer's expectation. We're dealing with someone who's incompetent in that particular area, is trying to do their best, working to the best of their ability, but simply failing to meet the employer's standard of performance. Their failure to adequately perform is not based on any willful action on their part or any act of neglect. It's strictly a lack of ability in their case. Whereas in the case of misconduct, we indicated they will not do the job. The claimant is not working to the best of their ability. And how do we prove that? Well, perhaps they've done the same job for 3 years. They've been promoted or received increases as a result of their competence and successful completion of duties. And yet now what we see is an individual who's choosing not to do that, who is willfully choosing not to perform their duties as they have in the past. Maybe they're neglectful in those duties. And certainly what they've done has caused harm to the employer, and that the claimant is fully aware of the consequence. In this case, you can see the difference between someone who is genuinely trying and someone who has just given up on the job and is choosing now not to do the job. So what is employer compliance? Remember that when we started the webinar, we talked about how this is a federally mandated program. In return for receiving federal dollars, each state receives federal dollars, there are things that an employer must do and a state must implement in order to have a program that's in compliance. And that's what I want to talk about right now. Every state was required several years ago to implement requirements on employers that they, one, respond to their unemployment claims, and that they provide timely, accurate, adequate information, or that they would face penalty. So what if you have a claim? And what if it's on an individual that you'd like to collect unemployment? And this does sometimes happen. Be aware that what you state to the individual at the time that you're letting them know that they're being let go, at the time you're letting them go that they're being dismissed, is what I must report at the time we respond to the claim. Responding to an unemployment claim is no longer a voluntary event on the part of the employer. In most states, we must comply with sending in a timely, accurate, and adequate protest, or the state will penalize the employer. And in some cases, they penalize the entire AlphaStaff account. We have never had that happen, and we hope to never have that happen. And so we will reach out to you to get separation details, and that's where we partner with you to make sure that we're providing timely, accurate, and adequate information. If you have a sensitive separation issue, we would encourage you to reach out to your HR manager, seek the advice of that HR manager, and be aware from today's call that what you say to the individual at the time of dismissal is what we need to be able to support if you wish this person to collect unemployment. If you're letting them go, letting them know that today is your last day and that you are making a business decision, that it's nothing personal, that you've decided going forward, and this is a right to work state, that their services will no longer be needed, or if you're letting them know that going forward that you do not feel that they meet the expectations of the position. Both of those are reasons that would entitle them to benefits, but I would still encourage you to meet with your HR manager, because there may be other factors involved that you would want them to consider on your behalf before making that decision, especially if the day prior there was a significant event that occurred or you suspect other issues may be there. It's always a good idea to get your HR manager involved. It's part of the service we provide. So what are some of the critical documents and best practices that we look to in managing unemployment compensation claims? This is a list that should benefit you, and this documentation supports your position. All of these documents are available to you either through your AlphaStaff portal, or you can reach out to your HR manager or payroll person for a copy. Some of them are also included with the printout of the webinar. So if this is something that you'd like to see, you should be receiving it with the webinar. The first one is an employee handbook acknowledgement. Now, this is an extremely important document. The reason is because when an individual is hired and we communicate to them what the expectations of the company are, what your general rules and guidelines are while working for the company, the last page of that employee handbook should be the page where the employee acknowledges that they've received a handbook, that they will review it, or that they have reviewed it, and that if they have any questions, they will reach out to HR, and that they agree to abide by the contents and rules set forth by the company. It's extremely important that we have a handbook acknowledgement. Many of you through Smart Start now complete this documentation through the employee portal, which is an excellent way to store those documents. They're available to us here at AlphaStaff. When we receive an unemployment claim, we can automatically resource those documents in collecting together the information we need to put together a protest, and you have an available ready resource of where they're located. We also seek the applicable portion of the employee handbook. Again, something usually AlphaStaff already has on file. If you've discharged someone for a violation of company policy, then I would want that applicable portion of the policy to show that this person was made aware of the policy at the time of hire. Something I'd like to say about that as well is if you have a zero tolerance policy, it's important that that policy be in writing. Having a zero tolerance policy that is not written down, that is not specifically stated in the employee handbook, places the employer in jeopardy of not being able to prove, unless it's something blatantly or in violation of some criminal code, of not being able to prove that it justifies immediate dismissal or that the employee was aware it was zero tolerance unless they admit to it. In addition to the forms that we've just discussed, another one that is also extremely helpful to us is the employee counseling verification form. The employee counseling verification form, and there is a sample in this packet, is used when an employee is verbally warned, with a first warning, with a second warning, a final warning, and also used at the time of termination. You say, why a termination? You're not warning. Because what occurs at termination is probably one of the most important things that we need to have documented. I need to know, what was the final incident that caused separation? How did it occur? Who was involved? And then we also want the other counseling verification forms to make sure that we can present, if this incident didn't justify immediate dismissal in and of itself, that the person was aware of the policy, knew they were subject to it, and the consequence for violating, and that this was a repeat of that violated policy. In addition, we look for witness statements, and I would encourage you to get the witness statement at the time the incident occurs. Please don't wait until we reach out to you saying we need a witness statement because now we have an unemployment claim. Witness statements need to be written while it's still fresh in the mind of the individual who was an eyewitness, not someone who told management and then management wrote it down on their behalf, unless you are then turning it back over to the individual and having them sign indicating, yes, it's true and accurate of what they were advising. It's important that the person who was directly involved, ear witness, eyewitness, write down what occurred, especially if the employer is taking action based on what someone else has stated. And I will discuss that as well. An employee attendance calendar, again, a critical document as in terms of keeping track of why an individual is not at work. What was the reason for calling in, or did they not call in? Was it something that was considered an excused absence, but their absences are excessive? Or was it for a reason that you don't consider justified and it was considered unexcused? The state's going to look at all of that information in determining whether or not this individual is guilty of misconduct if it resulted in dismissal. The other thing they look for in cases involving attendance is, did this in and of itself, are all of these related to tardies and now you fired for an absence? Or were all of them related to absenteeism and then the final incident was a tardy? The state separates the two and they look to make sure that the employer is properly documenting. Also listed here and sometimes used is the performance appraisal form. A performance appraisal form is very helpful because if this individual was discharged for misconduct, and we show on a performance appraisal form that they did a great job in the past, and now that work is not up to standard and they're coming in late, the performance appraisal can be used to establish that the employer was monitoring this and that this has changed due to no fault on the employer's part. Or it may be that the performance appraisal establishes that this was something that was an ongoing problem. And while you're frustrated that it went on for so long and you'd like us to fight the claim under misconduct, perhaps it is actually a poor performance issue where the person simply never met expectations, but what was most frustrating was the consequence of all their mistakes. That in itself, for example, would not be a disqualifying claim likely. Resignation statement. Often, we have situations where individuals will advise the employer they're resigning, everything is great, they go to a new job, it doesn't work out, they apply for unemployment, and when they apply for unemployment, there's insufficient wages from that new employer, so the claim comes to the next to the last employer, and lo and behold, it's changed to a discharge. Or it's changed to a quit because the employer did this and this and this and this, and none of it's documented. So please, if someone communicates to you that they're resigning, ask for a written resignation statement. Send them an email, even send them a text if that's your customary method of communicating with the person, letting them know that you acknowledge that they're resigning and you wish them well. And that response that you get back confirming the last day worked or that they've provided you with that written resignation statement should become part of their file because it's essential to us. Exit interview. Some employers do conduct exit interviews. They're very good for all types of employee relations reasons. But again, if the employee was unwilling to tell you at the time of dismissal that they were dissatisfied with their supervisor, that they were disgruntled, working around employee ABC, and that there were other terms and conditions of the employment that they felt were unfair, they can't later advise the employer that this is why they resigned. Lastly, the Notice of Employee Separation form. This form we rely on heavily because it is also a document that's used by our payroll department to communicate why the person separated. What do you want to think about when you're documenting? What are some of the important things you should consider when documenting? One, the length of time between warnings. If this person received their first warning in 2006, and then they received an unrelated warning in 2012, and then another warning after that, and then were discharged in 2018, the state's going to throw out all of those warnings. They're going to say there's not enough that's taken place that's been documented to show that this is grounds constituting dismissal. So consider the time between warnings if you're going to use the warning to justify dismissal. It should be at least within a year. That final written warning should be at least within a year. And quite honestly, it should be even sooner, depending on the type of infraction. We need a legible copy of the documentation. And let me say on that, included in the legible copy of the documentation is a legible signature or printed name underneath so that we know who to contact for firsthand testimony or has firsthand knowledge of the facts. Consider also the supporting evidence related to the warning, especially if the individual refused to sign. Do you have supporting text messages from the individual? Do you have time and attendance records or emails? Or do you have witness statements? All of those things are documents that can be extremely helpful. Are there prior warnings? And if there are prior warnings, do they relate to the reason for termination? And is this policy, is this infraction based on a written policy? Is it a policy in the employee handbook, or maybe it's in your operations manual? If it's in writing and the person acknowledged it, we are in much better shape than if it is not in writing, because the individual's in a position where they can say, I didn't know, I didn't realize. This is a picture of the the counseling verification form. And you see on this, where there's an opportunity for you to write in the person's name, who the manager is, very important. You're writing whether it's verbal, written, final, or termination. You're checking off in the next area the nature of the offense. Under that, you're writing down the type of disciplinary action, and this is an opportunity to document the history again of the individual, which is important for a lot of reasons. One that I think of immediately is that what's the purpose of our employee counseling verification form? Is to identify for the employee the standard of behavior that is not satisfactory so that they can make the necessary change to improve. Identifying for them previous disciplinary action helps to solidify the importance of why you're meeting that day and the seriousness of the employer's intent if they do not improve. Get it signed. Have a witness present when the incident is taking place. It could be a witness on the telephone. Don't wait until you have 2 people present unless there's some other reason for doing that. It may very well be that your witness is the person on the telephone. You can send them a copy. They can sign it. You certainly are going to introduce them to the claimant while you're on the phone so that everyone knows who is participating in the meeting. If the employee refuses to sign, you acknowledge that the employee refused to sign, writing that on the line, date the document. Everyone needs to sign it. It's extremely important, and it happens all the time. It's a tense situation. You're meeting with someone, you're confronting them about their behavior. You want it to be a positive meeting, but maybe it doesn't go so well. It's still very, very important that every individual who participates signs, or that they document that the employee refused to sign. And I also always share with my witness that it's important for the witness to be taking notes. The witness's job is not to just listen to what's taking place. That witness needs to write down what's being said during the meeting and be able to write down in detail. And that should be part of the documentation that goes with this document so that the employer has a detailed record of what took place that day, and it should be signed. This is a copy of the employee attendance calendar. It's available to you in PDF. It's also available to you in an Excel format. You may choose through your time and attendance program to manage attendance in some other way, but what is very important is that you're identifying by day what the problem was, and if you're taking disciplinary action, that you're not only listing that something happened that day that was unexcused, but you're listing why it was unexcused. And if the person called in, what was the reason that they gave for calling in? Who took the call? What time did they call? All of those things are important because it will be necessary if you later determine to discharge someone for misconduct and it's related to attendance. This is the Notice of Employee Separation form. And on this form, it's divided into several categories in the center of the document. The top of the document, you're putting in the employee details, where they worked, their last day worked, and as well as the termination date. The bottom portion of the form, you're noting any remarks. Many times the remarks section is also used in the notes section of the payroll section, or payroll system, so that we have that information available. And on the next screen, this is actually a close-up of that body section, the middle section of the form. And you can see that it's divided into resignations with and without notice, discharges for misconduct, poor performance, lack of work, and miscellaneous. Check off the most best identifying factor for why the person was discharged that day. If you check off 3 or 4, then we don't know which one. Please include remarks so that we can identify what the problem, so that you can better identify what the problem was. But pick the one that best identifies why you are taking the action of discharging this person on that day. Please remember that the section called poor performance usually are reasons that would entitle a person to unemployment benefits. as well as the next section, lack of work. Those are two reasons that would entitle a person to unemployment compensation. This is just a sample of an exit interview form, and we did discuss how important it is to have a neutral party not related to the person's direct report conducting an exit interview. There may be things that on behalf of the company would be good to know, or it may very well be that it's information that later becomes beneficial to us. So what are some of the best practices? One, document immediately while it's fresh in your mind what the behavior or performance was that was not acceptable. Communicate what the standard is that's expected and what the consequence would be if this person continues to neglect their duties. Use objective language. Make sure that you're not identifying the person in a derogatory way. Again, the corrective counseling is to identify a standard so that the employee can meet it. What's another reason or another critical best practice? Terminate weak performers who show little or no improvement as soon as possible. Unemployment compensation liability begins to build the day that a person starts. There are some states where the employer is granted relief from liability if they make the decision to terminate. In Virginia, for example, within the first 30 days, in Florida, within the first 90 days, in Illinois, within the first 30 working days. All of those things are good to consider. But as an employer, many states do not have the benefit of those small provisions in those states that do. Therefore, reduce your liability by making the decision as soon as possible to let someone go who you've identified is not going to work out. Reduce your liability by minimizing your liability. In cases involving misconduct, remember that the burden of proof is on the employer to establish why this person was let go and to prove that the individual was guilty of misconduct. It has to be final incident driven, and the termination needs to be in close proximity to the final incident. If it took you several weeks to make the decision to dismiss, the state is going to look at why was this person allowed to continue working then. If you are unable to dismiss right away, then I encourage you to suspend immediately pending investigation so that you can show that the employer took what occurred so serious it was necessary to remove them from the workforce. We don't want to turn a case of misconduct into a discharge for employer convenience because the discharge was not timely, because you waited until you found someone new and you got them trained, and then you said, oh, we're letting you go today because of that thing you did 4 weeks ago. The state will not accept that. And I realize that's a very unique scenario. Most employers would never do something like that. But it is important that we can show that we took action swiftly based on the severity of the act, and that's why they were discharged. Be consistent. Make sure that how you treat one employee is how you treat another and that you can prove it. And 2, allow resigning employees to work out their notice or pay for the notice period. I have not discussed this, but critical to unemployment is understanding that if someone resigns, they give you 2 weeks notice and you advise them, hey, don't worry about it. It's not necessary that you work out your notice. Today can be your last day. We won't need you anymore. You may have just converted that claim from a voluntary quit to a discharge. And if there wasn't an incident that occurred on the day that you decided to let them go, then it was discharge for employer convenience. Many states are set up that way. So have a practice of allowing resigning employees to work out their notice or pay them for the notice period. Or if you choose to dismiss during the notice period, consider it a case of misconduct and be prepared to document why you took that action. Can you prove it? The same rules that we've discussed today in terms of burden of proof apply. And lastly, provide timely, adequate, accurate information to AlphaStaff so that we can do a good job at protecting your unemployment tax account. What are some of the special provisions? One I was just talking about, which are probation periods. Here are some of the states that have those probation periods. Florida, as I mentioned, 90 days or less. Illinois, working 30 days or less. Maine, 5 or fewer consecutive weeks. Missouri, only 28 days. North Carolina, employed for less than 100 days. Virginia, employed less than 30 working days. In most states, they require that the separation have occurred due to competency, where we're dealing with someone who tried their best and simply didn't meet the standard of performance. If you're firing due to in this period of time for misconduct, then generally the same rules are going to apply. We need to prove that it was misconduct. So how do we partner together? And it is important that we partner together. We will do our very best to respond to your unemployment claim, but we can only respond as good as the information that you provide. When a claim comes in, we will reach out to you for separation details. Please, 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 because the state only gives us sometimes 24 to 48 hours to send in really detailed information. Respond to our inquiries. Typically what happens is this: we get a claim, we reach out to you, or we may have sufficient facts to file an initial response. The state then comes back after talking to the former employee and says, hey, that former employee has said this. We need a rebuttal from you. You have 48 hours. And that's when we reach out to you with very detailed requests, asking that you provide us with the information that likely will win or lose that claim. We then notify the state of that information, communicate, and we will, in all cases, monitor the case, hopefully with favorable result. However, if the decision is not in our favor, we will evaluate and make recommendations on whether or not we should take it to the next level, which is an unemployment hearing. And fortunately, here at AlphaStaff, we participate in those with you. We will represent you at the hearing. We will prepare your witnesses, send in your documentation, cross-examine the claimant, make sure that your witnesses say what needs to be said by also examining them, and enter a final argument on your behalf. Where we're permitted to do so, we will take it a step further if necessary, but typically you should consider this the very last step in the administrative appeal or claims process. Beyond this usually means it's reviewed by a third part or a 3-member body. The existing documentation is all that's reviewed. The existing evidence from the hearing is all that's reviewed, and they're not looking to see if they agree or disagree, only whether or not the ruling was within the merits of the law. The judge gets to decide how they weigh the facts. They will not reweigh the evidence. And what else do we look for in partnering with AlphaStaff? We ask that you utilize our HR managers, that you timely respond to our inquiries, that you follow best practices that we've discussed today, and that you provide AlphaStaff with separation details and supporting evidence. We can be reached at any time. We are a department right now of 2. Myself and KN Walker, and you see here on screen our contact information. I can be reached at 954-267-1847, and KN Walker can be reached at 954-267-1830, along with our fax and email addresses as well. And we do have a group email, fax, and group phone number as well, which we monitor. So we're available here to you. I hope today's information has been helpful, and I'd now like to offer you an opportunity to ask questions.
Thank you, Pam. I'm not seeing any questions in the chat feature, but I do want to stress that everybody on the call should have access to an HR account manager that you can reach out to, or as Pam showed you a moment ago, you can reach out directly to Pam or KN or to the Unemployment Compensation Department in general. So please make a note of those numbers, and I want to thank everyone for being here today. Thanks again, Pam.
Thank you. And thank you everyone for joining the call.